Well, good afternoon, everybody. Welcome back from lunch. We're just about ready to start our session 3 of the day. It will be on enforcement. Steve Whitley is here to give the presentation. Just a reminder that we are recording this session, and once again, you'll be able to find the recordings this coming week on our website. And as we have done in the previous 2 sessions, please type your questions into the chat, and we will get to them as many as we can during this session, and otherwise we will hold them for the remaining session of the day, the Q&A at 2:15. So that's all I have, and you're welcome to start, Steve.
Thank you, Ken. Nice to see everyone again. If you were at the morning session that I did with Matt Surge, you may notice I'm in a different location now. I understand there were some issues with the sound quality for that earlier session, so I hope that this is a little better. As Ken mentioned, this is all about enforcement. I'm going to be covering code and land use violations. That's me right there. And so code enforcement basics. So, where does it start? Well, it's typically when you get a complaint. It could be in person or over the phone. If it's over the phone, really should memorialize it in writing, just so you remember all the details you heard. Try to get the complaining party to allow their name to be used. Written complaints are governmental records, and so I have seen instances where people make right-to-know requests for the actual complaint. And typically the name on the complaint is fair game to be released. So that's just something to keep in mind. Then you're going to investigate. Can you observe whatever the alleged violation is without entering the property? Hopefully you can from the right-of-way, or maybe it's visible from an abutting property. Aerial photographs, Google Earth can help you. It depends on when those photographs were taken. If the violation is not visible, do not enter the property without owner consent. So I want to say that again. Do not enter the property without owner consent. You can go, however, to court and get what's called an administrative inspection warrant under 595B. That can give you the requisite legal authority to enter the property without the owner's consent. And then, once you're able to make observations, document them as best you can. Pictures, video, really key, because we're going to be in front of a judge or the Housing Appeals Board, and a picture is worth 1,000 words. It really, really demonstrates pretty well what the violation is. Notice. You should disclose to the owner what the violation is, and include in that written notice a deadline for compliance. The notice needs to cite the code sections being violated. The written, they obviously should be in writing. They need to be sent certified return receipt and first-class mail. Return receipt is really useful because you have proof of when the property owner received that notice. I see it all the time where people refuse to sign or pick up those certified notices, and that's why I have here to send via first-class mail as well, because then you can make an argument if you need to, that yes, the certified mail was never signed for, but we also sent it first-class mail to the address of record, and it was never returned, so presumably they received the notice. Hand delivery is necessary in some instances as well, when you really have a tight time frame and want the violator to know that they need to cease and desist immediately. If your notice involves the interpretation of the zoning ordinance or the enforcement decision, then they have a right of appeal to the ZBA pursuant to 676.5. So when you have to take the next step and go to court, you're probably looking at Superior Court, and this is not necessarily for an appeal of a land use decision, but this would be, appealing either building code or someone that's not compliant with a land use decision that's already been rendered. So the Superior Court, they have broad equity powers, so they can issue what's called an injunction. Those are the sorts of orders where the court is telling the property owner, you shall not violate again in the future. Superior Court's usually better for complicated cases. If you're dealing with a pro se party, it might be a more difficult forum for them, but it's a lengthier process and it's probably more expensive. District court, District Court is good for, I'm going to pause for a second here. Sorry, guys, I'm obviously at home and have a dog that is a really good guard dog. So District Court is good for cease and desist orders, for straightforward violations. However, District Court doesn't have any equity powers. So remember I said just a second ago, Superior Court, those injunctive relief orders, District Court cannot order those. District Court can fine someone, but they don't have any of that equity jurisdiction. So it can be more efficient. It's a little less expensive, and depending on what you're enforcing, you may really want the availability of those equity powers. So it really depends. Self-help, let's just not do that. Okay. No enforcement without a court order. Highly, highly recommend against that. You're asking for a whole lot more trouble than it would be to simply go to court. What are you enforcing? So when you render these violation notices, you need to identify up front what statutes, ordinances, or regulations that you're applying. And when you do that, you need to be mindful of who has the authority to enforce those. Who's going to sign that letter that goes out to the property owner? If it's code enforcement, zoning enforcement, it's probably your building inspector or your zoning administrator. It could be your fire chief. It could be the health officer or the governing body. I think what you'll see, though, here is that land use boards do not have enforcement authority. So the notice of the violation is not going to come from your board. And many times you'll have something where there's a violation of more than one ordinance. And so you may need more than one person to sign that violation notice. It may need to be signed by the zoning administrator and the fire chief. So just keep that in mind. Penalties for when you violate. Lots of options here. The injunctive relief at the top, that's the one I mentioned where you can only do that if you're in Superior Court. If you're in Superior or District Court, you can do civil penalties, attorney's fees and costs, cease and desist. All of those are the options. And other than injunctive relief at the top there, all of those are available in both of the courts. And some of them specifically in District Court, in fact. So this is a bit of a divergence from straight land use, but we see a lot of times that the properties that are violating one thing are usually violating something else as well. And many times it involves a public health nuisance, a fire hazard. It could be a hazardous or dilapidated building, or maybe it violates a housing standard. So the public health concerns fall under RSA 147. That's a state law. It empowers your community to adopt local regulations that are specific to public health concerns. But even if you don't have any local regulations, you can use this law and you can enforce against sanitary health conditions for being unlicensed, nuisances. This is the the law you would usually point to enforce against a public nuisance. And the health officer is empowered here to investigate dangers to the public health, to order the nuisances to be removed, to remove them after notice, and to recoup expenses. The health officer also has the power to order a building vacated if there's a clear and imminent danger to the life or health of occupants or other persons. And there's similar authority, and we'll get to this in a second. There's similar authority for other officials to order a building vacated, but the health officer is one of the ones that does have that ability. Fire hazards would come under Chapter 154. The fire chief can make regulations to eliminate the fire hazards. Fire chief also has the ability to inspect buildings where any combustible or hazardous material is stored. Can inspect an area if they believe that the material is accumulated or is liable to be accumulated. And again, can order occupants to vacate a building under that same standard as I just mentioned. Hazardous and dilapidated buildings. This is actually, I think, a fairly powerful tool that your community can utilize. This statute, it gives the governing body the ability to order the repair and removal of hazardous and dilapidated buildings, and that's defined. And that means that because of its inadequate maintenance condition or abandonment, it constitutes a fire hazard or a hazard to public safety. So when you're making this case that a building or structure qualifies under this statute, that's what you need to hone in on, is does the building constitute a fire hazard or a hazard to public safety or health? Minimum housing standards are under 48A. Again, you have the authority to adopt ordinances which are specifically addressing housing standards in your community. 10 residents can petition and require an investigation. And there are minimum standards for any landlords renting premises. The International Property Maintenance Code. This needs to be adopted like a local building code, but it contains minimum maintenance standards for basic equipment, light, heating, sanitation, fire safety. The 2001 version is available online, and it should be updated this year. And it applies to all existing residential and non-residential structures if you adopt it. Just another tool in the toolbox that you could potentially use. And this also is helpful if you're dealing with a dilapidated building, because you can cite to the provisions in this property maintenance code for the standards that are not being satisfied. Okay, so keeping with the code theme here, the state building code and the state fire code. The state building code comes from 155-A. It is the International Code Council 2018 version of all of those specific codes listed there. The fire includes the electric code from 2020, and under the building code statute, your community has the ability to make changes or amendments to that code which make it more stringent than the baseline ICC version. All new buildings have to comply with the state building code, regardless of what your local community does. They apply at the state level. In addition, buildings that are altered, renovated, or repaired also need to comply. In some communities, you need a permit to evidence that you comply with this, but maybe not every single one of them. Even if you don't need a permit, though, you have to comply with the state building code.
Okay, excuse me, Steve.
Yes.
We have a hand raised. First of all, just if the person raising their hand has a question, please just type it in the chat. But is there something that is some other reason you have your hand raised? Let me see if I can mute. Okay. I've allowed your mic, but as I say, if you have a question, just please type it into the chat.
I see one question about drone photos. I can address that one now. I don't know if that's what was being asked.
I don't think
But
so.
yeah, drone photos, I typically recommend against that. For one thing, there's the issue of compliance with the FAA. But let's assume that you comply with, you don't run afoul of the FAA regulations about operating a drone. I think if you're going to rely on drone photos, you're going to run into Fourth Amendment search and seizure objections, and I think they would probably be well-founded. And the situation I think of is if you have a property owner and they have a 12-foot privacy fence around the entire perimeter of their property, arguably they have a pretty good expectation, a reasonable expectation of privacy. And flying a drone over their house without their express permission or without a warrant or some other exception to requiring a warrant, I think is going to lead to quite a few issues that are probably not worth it, particularly where you can use the 595B administrative inspection process, go to district court, get permission to enter the property and document any violations you see. That's the much more sound way to address not having good evidence to use for an enforcement action. So I would advise to steer clear of using drone photos. Okay, so
I was unable to, I'm unable to use the chat for some reason.
Okay.
I think that's a key question.
Do you have a question right now?
No, but I would try it a little earlier. So
Okay. All right.
But for some reason, I have no window to, the chat opens, but I can't find a place to enter anything.
Okay. We'll see if I can have somebody help you with that.
Okay, thanks.
Thanks. Yep.
Okay, I'm gonna keep going here. So I think I left off, I may not have hit this one. So which version of the building code applies? It's in effect, the version in effect when the application is received. That's the one that's operable. There's a 6-month period though that the state can change it and the applicant can choose which version they get to use. So just bear that in mind. Building code enforcement at the local level. If you're going to do this, there is a process you need to have locally enacted to do that. You have to establish the Building Code Board of Appeals. Many communities that do have this local process, they make the ZBA, the Building Code of Appeals. You need to have a position of a building inspector, a fee schedule, and you need to require a certificate of occupancy. When you do that local enforcement process that you adopt at the local level, that does require state review. There's a state building code review board. You have to send your amendments to them, and they need to confirm that you're not conflicting with the state building code or requiring something that's less stringent than the state code. And there's a process you have to follow, and there's some further details there about that. After you have to have a public hearing, you have to provide evidence that you held the public hearing, and the process that you have to follow to provide the amendments to the state building code board of appeals. I butchered that. You have to follow that before you can enforce the amendments that were enacted. If you are making amendments to the state fire code, those have to be submitted to the state fire marshal, again, to confirm that they are not in conflict and not less restrictive than the state fire code. If you can request state assistance in enforcing the state building code. If it requires specialized knowledge or municipal staffing limitations prevent you from being able to do it, you can ask the state fire marshal for assistance as well. The fire marshal, though, does not have to, is not obligated to provide that assistance. This is just running through the current version of the fire code. It's the life safety code, the uniform fire code, NFPA 101 and NFPA 1. It also includes the administrative regs at SAF C6000. This applies to new construction and renovation, existing buildings as well. Again, can be amended by the fire marshal, acting with the Board of Fire Control and the Commissioner of Safety, and then ratified by the legislature within a year. So pretty cumbersome process to amend the state fire code at the state level. All right, enforcement of the fire code. That's the local fire chief in your community. The fire chief can inspect buildings for fire prevention purposes. When they provide a notice of a violation, that needs to include the local appeal process and the state variance process. And so the fire code is interesting in that you can't seek a variance from the fire code at the local level. You can only do that at the state level. And a lot of times there's some overlap between the fire code and the state building code. And so when that happens and you're enforcing both of them, you're going to look to whatever code provides the greater degree of life safety. And that's the one that's going to govern if there's a conflict. Okay, so Building Code Board of Appeals. I just mentioned this, that if you adopt the local enforcement process for the state building code, you're required to have this Building Code Board of Appeals. So, what is that and how do they operate? They can hear appeals, but their jurisdiction is actually pretty limited. They need to determine whether the true intent of the code or the rules has been incorrectly interpreted, or whether the provisions of the code don't really apply. And they'll also examine whether an equally good or better form of construction is proposed. Similar to the state fire code, the Building Code Board of Appeals, again, this is at the local level, cannot waive requirements of the state building code or the state fire code. That can only happen at the state level. So it gets kind of confusing if your Building Code Board of Appeals is your ZBA, because the standard that's being applied is not the typical ZBA standard. And so when that happens, I think it's a really, really good idea to have a conversation with the ZBA acting as the Building Code Board of Appeals to remind them of how their standard of review is different than maybe what they're accustomed to as a typical ZBA review. Okay, I want to get back to ordering a building vacated. Again, it can be ordered by more than one official: the health officer, the building inspector, the fire chief. The standard to have a building vacated is different depending on who occupies the building. If it's occupied by the owner and immediate family, the standard is much, much higher. And it is, you can only order it vacated unless the condition is a clear and imminent danger to people other than those occupants. And if you think about that, that is a really, really high bar to clear. So you're not saying it's a danger to the people that are living there. You're saying it's a danger to people that are not occupants of that building, so the surrounding buildings. If you pursue an action like this and the court thinks that it was done in bad faith, the property owner or the occupant, they can be awarded their attorney's fees for having to defend. Hoarders. This is a situation that I think most communities have some experience with. It's really a pretty unfortunate circumstance. And that's because it's a human behavior. It's like a compulsion that they have to collect things that they feel they have an emotional attachment and a need for, but it creates really, really serious health concerns and hazards. And so I think a good rule of thumb is to really, really try to avoid any sort of judgment on them. And don't do surprise cleanups either. That's a recipe for conflict. When there is a clear danger, you can consider some more direct action. But you really need some good evidence to be able to do that. And that would be, it's necessary due to the odor and the waste, like a public nuisance, or the pests or disease that the rodents and the pests that are attracted as a result, a public health issue. There is a task force in New Hampshire that looks at this. It's the New Hampshire Public Health Nuisance Task Force, and they have a good definition of what a nuisance is there at the bottom of this slide. To deal with the hoarders, try to get in touch with the family or friends and see if they have any leverage with the hoarder to try to get them to adjust their behavior. If it's rental property, get in touch with the landlord. If you think it rises to the level of self-neglect or abuse, there's the number for the Bureau of Elderly and Adult Services. If you have reason to believe that there's suspected child neglect at this dwelling, contact DCYF. Those are two areas where I always tell the communities I work with, that those are really state issues, and you need to hand those off to the state agencies that are responsible for them. They are aware of how to address these problems and frankly, have the authority to do so. Neither one of those situations is really within the local community's purview, and so you really need to hand them off to the state officials. Private covenants. This is something that we get a lot of questions on. You'll have a property owner that's before the zoning board or the planning board, and they'll say, or actually an abutting owner will say, they can't do this. There's a private covenant that says that they can't do this, so you have to deny this application. And unfortunately, that's just not something that's within the power of the ZBA and the zoning or the planning board to enforce. That's a private issue. And so what that means is that it's something that needs to be taken up by the private parties and shouldn't involve the town or the city. And covenants, just to give some examples, it could be homeowners association, restrictions on how a property can be used. It could be restrictions in a deed. Someone conveys the property to the next owner in the chain of title, and it says, you can't use this property except for single family residential use. Or it could be easements that are held by adjoining landowners. The easement one, just before I move on, the easement one, although the planning board and the zoning board can't enforce the terms of that private easement, the easement may be relevant to what is before the board nonetheless. So I don't mean to say that, when someone says, they can't do this because of this easement, that you should not consider what's being argued. It's just that the ZBA and the planning board themselves cannot enforce the limitations of the easement, but it still could be relevant to the application that's before the board. Junkyards. I think this is an issue that cuts across probably every community in the state, and it's really something that communities should address. The state law requires that if you're going to have a legal junkyard, they need to be licensed and their location needs to be approved. And the reason for enforcing the junkyard statute at the state level and the local level is that it can have a really, really significant impact on the neighborhood that it's in. It can impact property values. It can be a public health concern. And it's also, I think, just politically a bit of an easy target for people to complain about. That's typically how they come to my office, is that, the communities that I help, the governing body or the zoning administrator will say, we've gotten so many complaints about this property, we have to do something. How do we wrap our hands around this and address this? So this is a flow chart that sort of works through how you should tackle a junkyard in your community. let's take the yes line first. First, you're going to ask, if it is in fact a junkyard, is it licensed? And if it is licensed, is the use permitted under your zoning ordinance? And if it's not a junkyard, then you want to see if there's any other enforcement leverage that you can apply. Does it violate any health, safety, or welfare laws? Is it a hazardous and dilapidated building? Does it create a nuisance, a fire hazard, or a housing standard? So when we talk about whether or not it's a junkyard, we're talking about this state level definition. And there's a good bit of nuance in this. And so you may think that a particular property meets this definition, but you really need to give this a pretty rigorous review because there's more leeway here than you might think. And there are certain categories of junkyard to keep in mind: automotive recycling, machinery, and motor vehicle. I think the biggest one that we usually see is the motor vehicle junkyard, but it's not limited to vehicles. I mean, you can have properties that just have piles of trash on them, and that's a junkyard under the state statute. Yeah, and again, it's not how the owner uses it. It is the presence and accumulation of the junk that really matters. And if you are talking about the motor vehicle situation, vehicle registration is no longer the standard. It's whether or not the vehicle is fit for highway use. And so registration doesn't necessarily establish that fact. And so there's a little more investigation than merely are the vehicles registered or not. The last bullet there is really a pretty critical one. Does your zoning ordinance does your zoning ordinance regulate junkyards? Many communities do. I've seen a lot that don't, however, and we're going to get to this in a second, but I mean, the state law gives you some enforcement mechanisms, but they don't have as much teeth as enforcing under your local zoning ordinance. And so that's why a lot of communities, even though it's regulated at the state level, a lot of communities have their own junkyard regulations that they can use to enforce, in addition to the state level violations. Going back to that flow chart we looked at, if it is a junkyard, is it licensed? It's required to be licensed by state law. This is a separate requirement from the zoning ordinance. There are no grandfathering, no vested rights for the license requirement. So even if the junkyard has been in operation for 100 years, it has to have that license from the state level. If it's licensed, if it is a junkyard and it's licensed, you need to look at whether or not it's allowable under the zoning ordinance. And that's because the state statute about junkyards says if there's a conflict between the state regulation of junkyards and your local ordinance is going to prevail. And so hopefully your definition of junkyard is very similar to the state level definition. Many communities simply adopt the state level definition by reference. That's the cleanest way to do it. And so if your zoning ordinance addresses junkyards, you're going to look at, obviously, where is it allowed? Are there certain zoning districts where it's prohibited or you need a special exception in order to operate it? And then if it clears that zoning review, you need to get an approved location, you need to have the location approved as well. There are some exemptions under the junkyard statute. If it's a motor vehicle dealer and it's registered with the director with DMV, and it's their principal place of business, then it's not a junkyard. And that, I think, intuitively makes sense. The Motor vehicle dealer, it's their business to have vehicles on their property to sell. As long as they're registered to actually do that business and it's their principal place of the business, it makes sense that they wouldn't be subject to this. The other one that can be really tricky is non-commercial antique motor vehicles. There's actually quite a bit of language in the statute on this, and a lot of conditions that have to be satisfied to fit under this definition. But sometimes you'll have a property owner that can tick all of them off, and unfortunately, that probably means that although it may appear to be a junkyard, they may fall into this exemption, and you'd be unable to enforce against them. And at the bottom here, just to note that if we're talking about the principal place of business of a new or used car dealer, it's typically not a junkyard, even though it could have on it a good amount of wrecked vehicles or vehicle parts. And again, that's because of the way that the state statute carves out some exceptions to whether or not you're considered a junkyard. If this is a state level, I mentioned that the state has regulations separate and apart from anything you may have at the local level. This is what the violations would subject the owner to at the state level. It's a civil penalty. It could be enforced as a violation. You can go to Superior Court, again, not district court. Superior Court to ask for an injunction. That's an order for them to stop using the property as a junkyard. You can even do a citizen complaint. In addition to all that, it could also be a zoning violation, which you would enforce separately under your zoning ordinance. Okay, I have run through my presentation, and I know I did that fairly quickly, but I wanted to leave some time for questions. Because the earlier one I did, we did not have any time for that. And so I did this a little bit quicker. So let's see here. I'm going to look at the chat here.
Yes, we have a question from about 20 minutes ago. I don't know if you found that from Tom Nyes or Knees.
Give me 1 second here, Ken. Let me
Okay.
Here. Oh, yes, I see it now at 101.
Yep.
Sorry, I'm just reading it. Yeah, no, it's a good question. I can't speak to why it was included in the ZBA track necessarily. I can tell you that how to enforce comes up quite a bit with ZBA members across the state. There is a misconception that the ZBA as a board has enforcement authority. And so that is perhaps the reason why this is part of the zoning board track, is just to educate zoning board members across the state that code enforcement and enforcement of the zoning ordinance is a separate municipal function apart from the ZBA. Let's see, I'm going to go down here, Ken. I see there's a couple at the bottom here. I'm going now to 112. What happens when the zoning ordinance conflicts with the covenants? Again, the municipality can only enforce the zoning ordinance, can't enforce the covenants. And so if the zoning ordinance allows it, but the covenants do not, then it's a private matter that needs to be dealt with by the private property owners and not the community. Okay, going to the next one. I have an open space farming zone. Does not. Leaving the residents in limbo. Yeah, if you're talking about a restriction that's in place because of a homeowners association, then that's a private issue, not a town problem. That's correct, Brian. Yes, and then Audrey, your observation about antique vehicles. Yes, if you are trying to meet the carve out for antique vehicles so that you're not quote unquote a junkyard, the state statute does limit how many of those antique vehicles are visible to the public. And I believe that number is 5. If, however, you have some sort of an enclosure that screens the view from the public as well as abutting landowners, you can have more than 5 antique vehicles on the property. This can be really, just to sort of follow this line of thought, this can be really hard for people in that neighborhood to understand, because if they qualify as an antique motor vehicle carve out to the junkyard statute, they can have up to 5 antique vehicles that for all intents and purposes look like junk in the front yard. And if they qualify as antiques, then they can legally have up to 5 vehicles visible to the public. And that can be really challenging to a town's enforcement efforts, and also challenging politically, because the owners that live around that junkyard are not going to be really happy with that. So I'm not seeing any other questions. Let's see here. Okay, we got some follow-up. Here we go. All right, so does someone need standing in order to file a citizen complaint about a junkyard? Yes, you do. Absolutely. So the citizen complaint would need to be by someone that's particularly aggrieved by the junkyard. So that would likely be somebody that's either an abutter or a very close neighbor. But yeah, you would need standing to bring that action. The next question asks, despite not having enforcement authority, can the ZBA ask an enforcement official to check on something to determine that conditions placed on an approval are met? Yeah, absolutely. I mean, look, anybody in a community can contact the code enforcement office and say, hey, I think there may be a violation going on here. Please investigate. But the ZBA can as well, the ZBA members, because you people that are on the ZBA probably have the best information about what conditions may have been placed on an approval. So yes, you can. Follow up to covenants. What if the zoning does not permit the use, but the covenant does? Again, you would go with the zoning ordinance. So if the zoning does not permit it, then you can enforce that, no matter what the private covenant may allow. Your concern as the municipality is only what the zoning ordinance allows or does not allow. And the last one that I have, at least for now, is what about encroachment complaints with one resident against another? Yeah, so if you're talking about encroachments or into private property, that's a private property dispute. If someone says that they're encroaching against their neighbors or their neighbors encroaching against them, that should not be a municipal concern. The question here mentions that a lot line adjustment would cause increased setback violations. Arguably, the planning board should not be granting a lot line adjustment if it creates setback violations. But typically, encroachment issues are private property disputes that shouldn't involve the town. Just see if we've got any more here. Okay. All right, so let's see, got a couple more here. Farming and buildings under RSA 2134A. Yeah, farming is, that's gotten a lot of attention recently, primarily, I think, because of farm stands and what's referred to as agro-tourism. And there is a a good bit of statutory language addressing whether or not those are permitted or not. And the baseline is that if your zoning ordinance does not specifically call them out, then they're deemed to be permitted uses. And then agritourism, there's usually disputes about whether or not that definition is satisfied or not. Because if it doesn't fall under agritourism and agriculture, then usually communities have more discretion to enforce against it. Got another question about, let's see, this one says, realtors are often using drone pictures. I'm in a private association. Can we ask them not to do that? I think that's more of a private issue, not really a municipal enforcement issue. And so I really can't, I agree with you that if the association doesn't like it, you ought to ask them not to do that. But, you know, whether they have to follow that advice or not, you know, I really don't know. Let me just refresh this one more time because we still have some more time. Okay. If a covenant disallows short-term rentals, but the town has no ordinance, what happens? That's a good question. So even if your community doesn't have a ordinance provision that is specific to short-term rentals, it probably means it would be regulated as, or I guess the question would be, does it fall under a residential use or is it some other type of use? And it's hard to answer that question in the abstract, but even if the zoning ordinance doesn't specifically call out short-term rentals as a category, there is a chance it still could be regulated as either a residential use or perhaps even as a business or commercial use, and it really depends. The question though says, what if the covenant does not allow short-term rentals? Again, the municipality cannot enforce private covenants. So if you have someone, let's assume that the zoning ordinance allows short-term rentals or is silent, but the private covenant does not allow them, the town or the city cannot enforce that private covenant. That has got to be done privately. Next question. We have someone who is licensed by FAA to fly drones and can take pictures from 200 to 300 feet in the air. Are you saying those cannot be used in a complaint? That would be my recommendation, correct. And the recommendation, and I say that because even though the drone can get up there and not run afoul of FAA guidelines, I think you're still going to have an objection raised that this is an illegal search. And unless you have a warrant or have qualified for one of the exceptions to having to get a warrant, you're going to have this long protracted battle over whether you can even introduce that evidence. And so rather than have that fight, which there's a good chance you're going to lose, go to district court, follow the 595B process and get an administrative search warrant that will put you on the ground in the yard or the land in question, and you can walk around and take pictures and gather all the evidence that you'll probably need for that enforcement action, and you won't have to have that battle over using the drone photos. Okay, let me just refresh here. Let's see. What do you have thoughts on HB 1215 freezing regulations on subdivided land? I am forgetting off the top of my head what HB 1215 did, so just give me a second to Google that. Ken, do you know HB 1215 off the top of your head?
Not off the top of my head. I can also check in with Noah Hodgetts in our office and see if he can give us that info.
I've got it right here. Just give me a second, folks, and I can Let's see. All right, let's see here. So this adds a paragraph to the 5-year exemption. Yeah, it looks like this exempts.
Steve's, the user is saying, sorry, it was the wrong bill.
Oh,
They've listed the wrong bill.
okay.
Okay.
I won't go down that road anymore then. Let's see.
Okay. We do have one more comment. I think this is following up on possibly on the antiques or the.
Yeah, I see it. Let
Junk
me just
vehicles.
pull up the
Okay.
statute here. Yep. Sorry, bear with me here, folks. Okay, so are we 111? Yeah, so the what was posed was a portion of the language from that particular statute. And the point I was making is that if the vehicles in question qualify as antiques, you can have up to 5 of those antique vehicles anywhere on the property visible to the public and to abutting property owners. If they don't qualify as antiques, then you're limited to no more than 1. But if your antique vehicles are in pretty rough shape, that distinction is not going to matter a whole lot to the people that live around that antique motor vehicle location. And that's the point I was trying to make, is that even though it qualifies as a quote unquote antique motor vehicle, it still may be in really, really poor shape, and could make the people that live around there feel like they're living next to a junkyard. Okay. Oh yeah, and there's a follow-up here. The language is unregistered and uninspected motor vehicle. Right. Any other questions? Not seeing any more pop up. Ken, are you seeing any more? I've heard any others?
Nope, I'm at the same spot you are, so looks like there are no other questions.
Okay. Well, there's a little more time, and so I don't want to end this unless people are satisfied. So if you have questions and you want to just pick my brain, we have a little more time, but otherwise you could probably have a little extra break before the next session.
Looks like we have the comment about HB 1215 is back. Might want to just look at that.
Okay. The subdivision is approved. All right, sorry, let me go back to. Sorry, 125. Oh, 1215. Sorry. Yeah, I agree with that. That this legislation would say that if you have an approved subdivision plan, site plan, or building permit, it's going to be exempt from all subsequent changes in the state building code and the state fire code. So at the time of approval, your need to comply is frozen at whatever the currently existing state building code or state fire code, whatever those requirements are. So yes, it would, those particular ones would be in effect indefinitely, but any changes made after that would not apply. So I guess I'm agreeing with the comment here. Yes, and it does include zoning. This particular bill would also include zoning. Yeah. Okay. Building code review board to hear appeals. There's a question about continuances. If you have less than 5-member board, but you meet quorum, how do you deal with that? The 90-day rule is not going to take into consideration having less than a full board. And so if you're have less than 5 members and you're coming up against that 90-day time limitation, you really need to work with the applicant to get them to waive that 90-day rule. All right, let me refresh here again. Back to HB 1215. I don't know if this statute would act. I think it would only act going forward, not retroactively. And so a garage building that's 20 years old, if the example that's being posed here is a garage that's already in existence and it's been there for 20 years, this statute, would not apply. It only applies going forward. Let's see here. Yeah, no, I read the bill the way that you do, Michael, that it is kind of scary to think about. So yeah, that's my interpretation of it as well. Anybody else?
Well, I think I'm going to say it's we're pretty close to 145 at this point. If you're still thinking of another question, I would recommend that we, especially if it's other topics as well, let's hold them until the Q&A session that starts in 15 minutes. And meanwhile, you have Stephen Whitley's contact info there if questions regarding enforcement occur to you. Meanwhile, thank you again, Steve, for your presentation just now, and also the one earlier this morning. And that's it for this session. Thanks again.
My pleasure. Hope everybody enjoyed it and learned a lot. And yeah, feel free to reach out, and I'll happy to follow up with any other questions that people have. So yeah, thank you.
Very good.